Hello, everyone. My name is Timothy Innes, and I am the Reference and Academic Outreach Librarian at the John F. Schaefer Law Library, Michigan State University College of Law, and Professor of American Legal History at Western Michigan University Cooley Law School. For several years now, I've hosted a podcast entitled the American Legal History Podcast, which traces the history of American law from its ancient roots to the present day. The American Legal History Podcast is available on the Apple Podcast platform. One of my listeners suggested it might be a good idea to create YouTube videos to parallel the subject covers on the podcast topics, and this is the first of those offerings. The subject of this presentation, the early Supreme Court and the legacy of John Marshall, reflects the materials presented in episode 21 and 22 of the American Legal History Podcast, and this is part one. Okay, I think that's enough of an introduction. The justices of the Supreme Court met in their first session on February 2nd, 1790 in the Merchants Exchange at the foot of Broad and Water Street in New York City. They wore beautiful black and scarlet robes, but had decided to dispense with what Jefferson called, quote, the monstrous wig which makes the English judges look like rats peeping through bunches of oakum, close quote. Despite the fine robes, the Supreme Court can only be described as ineffectual during the first decade of its existence. In fact, it handled remarkably few cases. Most historians would agree it handled only one important case, Chisholm versus Georgia, which held that the federal courts had authority to hear cases in law and equity brought by private citizens against their states, and that states did not enjoy sovereign immunity from suits made by citizens from other states. The decision had the unintended consequences of getting the federal and state governments to finally agree on something. They were totally opposed to it. The case was overturned by the quick ratification of the 11th Amendment, which immunizes states from suits for money damages or equitable relief without their consent. As the name implies, the legal concept of sovereign immunity has its origins in the kings of England, in that you could not sue the king. The federal government, as the sovereign of the people, had already acquired this protection. The 11th extended this protection to the states. The advisability of this protection has been mixed. For example, if an Indian tribe is barred from suing a state for robbing them of natural resources, as you can imagine, not an uncommon occurrence in the first half of the 20th century. But let's get back to the Supreme Court. The weakness of the early court was evident symbolically in the building of the new Capitol in Washington, D.C., and that they were completely overlooked. And no chamber was provided for them. Contemporary wrote, quote, a stranger might traverse the dark hallways of the Capitol for a week without finding the remote corner to which justice is administered to the new republic. All that changed after John Marshall of Virginia became the Chief Justice in 1801. His influence on the court and American legal history cannot be understated. The great constitutional scholar Bernard Schwartz said, quote, if American justice were to be represented by a single figure, skeptics and worshipers alike would agree that that figure could be one alone, and that one, John Marshall, close quote. James Garfield, our 20th president, said Marshall found the Constitution paper and made it power. He found a skeleton and he clothed it in flesh and blood. Marshall transformed the Supreme Court into a fully coordinate department endowed with the ultimate authority of safeguarding the Constitution. In the first 10 years of the Republic, there had already been 3 Chief Justices, John Jay, John Rutledge, and Oliver Ellsworth. The next 3, John Marshall, Roger B. Taney, and Solomon P. Chase, would preside over the court for 73 years. Marshall was a true American original. We don't really have time to get into a biography of his life, but my favorite story about him, and one that reveals what kind of person he was, goes like this. Marshall was not known to be very fashionable or even very neat for that matter, and one day when he was in Richmond, after he became Chief Justice. He was at a farmer's market when a man of obvious wealth walked up to him with a large butchered turkey, mistaking Marshall for some kind of servant. He handed Marshall the turkey in a 25-cent piece with instructions to deliver it to his home. Marshall looked at the man, looked at the coin, and delivered the turkey. In terms of the history of American public law, Marshall's greatest contribution has long been considered to be his decision in Marbury versus Madison, which laid down the doctrine of judicial review, the power to strike down laws that the court determines are unconstitutional. But it is important to understand, as we have seen in previous episodes, that the power of judicial review was just one of many problems in early constitutional development, but only one. Standard constitutional history has treated it as the central issue by putting Marbury versus Madison, 1803, at the center stage of the early republic's constitutional growth. But the history of the 1790s shows constitutionalism was hotly contested by several factions in American society outside the court. In short, American constitutional development in the first decade of the new nation cannot be reduced to a few Supreme Court cases. That does not mean Marbury versus Madison is not important. The case clearly shows the tensions on issues such as federalism, the distribution of power between the states and the federal government, and the separation of powers that had surfaced time and time again during the early republic. Looking at it this way, the case shows us the role of the federal judiciary and the Supreme Court in the era's constitutional development. Now, the actual dispute in Marbury versus Madison was the byproduct of the Judiciary Act of 1801. The Judiciary Act had been passed in the wake of the election of 1800 by a lame duck Federalist Congress. What it did was dramatically expand one branch of the federal government, the judiciary. The act called for the appointment of 23 new federal judgeships. In addition, the number of Supreme Court justices would be reduced to 5, and they would no longer be required to ride circuit. The requirement that the Supreme Court justices were obliged twice a year to travel to the seat of federal circuit courts to hear cases had proved to be a tremendous burden on men often of advanced age, forced to travel sometimes for weeks on the nation's terrible network of the roads. This requirement, more than any other, had led to a very high turnover rate for the justices. But as we shall see, this respite from the trials and tribulations of travel along the highways and byways of the young republic would be short-lived. And in fact, the justices of the United States Supreme Court would continue to ride circuit until 1863. In any event, President Adams rapidly appointed large number of Federalists to the judgeships, all of whom, as stipulated in Article 3 of the Constitution, were life tenured. A few weeks before Jefferson's inaugural, Adams appointed John Marshall as Chief Justice of the United States. At the time of his appointment, Marshall was serving as Adams' Secretary of State. In addition, just a few hours before the actual ceremony swearing in Jefferson as president, Marshall, acting in his capacity as Secretary of State and under Adams' direction, made a final round of midnight appointments, as they came to be known. One of these was for William Marbury, named Justice of the Peace for the District of Columbia. But he never received his commission in the end of the term bustle. In fact, it was later established that Marshall had sent his own brother that fateful night to deliver the commissions. But for reasons lost to history, he never made it to the Marbury residence. After Jefferson was sworn in, he directed his new Secretary of State, none other than James Madison, not to deliver the commissions. Marbury went directly to the Supreme Court, seeking a writ of mandamus. This is Latin for "we command." So a writ of mandamus is an order that requires another court, government official, or public body to do something so ordered. The first action taken in the struggle between the three branches of government came from Congress. For quite a long time, the Supreme Court sat for a very short period of time. In fact, at that time, it met for only about 3 weeks in the month of February. The Congress simply, and quite legally, canceled the 1802 Supreme Court session. Because of this tactic of delay, which was tied to Jefferson's effort to repeal the 1801 Act, Marbury did not get his day in court until February 1803. When finally argued, the case seemed to turn on two issues. One, whether Marbury was entitled to his commission, and two, if so, whether Jefferson could remove him. If they said yes to the first issue and no to the second, it would have triggered a fight between the executive and the untested judiciary. Marshall did an end run by injecting a third issue, and he writes the opinion in reverse order by leaving the pivotal jurisdictional issue last, and he structures his opinion in the following order. 1. Whether Marbury has a right to his commission, he demands. If yes, does the law provide him with a remedy? If yes, was that remedy a writ of mandamus from the court? First, he had a right to his commission if he was legally appointed. The requirement is it needed to be signed by the president and the affixing on the seal of the United States by the Secretary of State. Both were done, and the fact that it was not delivered was not important. He was entitled to remain in office for 3 years. 2. The office of Justice of the Peace is not the kind of office that could be, quote, removable at the will of the executive. To do so would be a violation of a vested legal right. And 3, a writ of mandamus would be the proper remedy in this case. One more thing. Does the Supreme Court have the power to issue a writ of mandamus in its original jurisdiction? And the court answered no. The court could not order Madison to deliver the commission because it lacked the authority. It lacked the authority to issue writs of mandamus in original jurisdiction cases. He came to this conclusion through an interpretation of Article 3 of the Constitution and Section 13 of the Judiciary Act of 1789. In his reading of Section 13, he rejected the view that mandamus clauses only applied to the court's appellate jurisdiction, even though the clause had appeared in a sentence defining that jurisdiction and separate from the sentence defining the court's original jurisdiction. This meant that if the court appropriately had jurisdiction in an original appellate case, it could issue a writ of mandamus. He then turned to Article 3 to determine the constitutional scope of the court's original and appellate jurisdiction. He read the exceptions clause of Article 3, which came in a separate sentence describing the court's appellate jurisdiction as limited to appellate cases. Thus, the mandamus clause of Section 13 needed to be understood in the light of a reading of the exception clause that precluded Congress from adding to the original jurisdiction of the court. The exceptions clause only applied to appellate cases, but Section 13 gave the court power to issue writs of mandamus to persons, quote, holding office under the authority of the United States. Issuing a writ of mandamus to an officer for delivery of that paper was the same, Marshall argued, as an original action for that paper, and therefore seemed not to belong to appellate but original jurisdiction. If mandamus was an original rather than an appellate writ, Section 13 was enlarging the court's original jurisdiction to allow it to issue a writ in a case like this. But that was inconsistent with Article 3 because the case did not involve ambassadors, public ministers, or consuls, or one in which the state was a party. Thus, Section 13 was unconstitutional. If you had some trouble navigating Marshall's tangled logic, you were far from alone. Jefferson called Marshall's talent for obfuscation in crafting legal arguments twistifications. In fact, the case is so convoluted and hard to untangle that I created this Marbury versus Madison flowchart for the benefit of my students. Most at the time it was issued saw it as a victory for Jefferson. Few understood the implications of the Supreme Court of the United States declaring a federal statute unconstitutional, but Jefferson did, and so did Marshall. And in fact, it was used sparingly in the 19th century. The Supreme Court would not invalidate a federal law on constitutional grounds until the famous Dred Scott decision of 1857. Historians have traditionally argued that Marbury's importance lay in its allegedly foundational act of judicial review. But now most agree that by 1803, judicial review was already established, and the more significant fact was that the opinion was a political intrusion into the general constitutional politics of the time, a judicial defense of a power grab by the lame duck Federalist Congress of 1801. As to the question of judicial review, it is a fact that in the post-revolutionary period, the doctrine that the people were sovereign and not government early led to the belief that the court must only implement those laws that were legitimately derived from the people themselves. This was the basic principle of judicial review. The Constitution is the physical and intellectual manifestation of the people's sovereignty. Several state courts had already invalidated state laws under its own state constitutions. James Ardell, a North Carolina lawyer and future Supreme Court justice, articulated this view back in 1786. Quote, "If all branches of government, including the judiciary, were bound by a constitution that represented the sovereign people's will, and if a case presented judges with two ostensible laws, one the act of the legislature and the other the act of the sovereign people, the judiciary must apply the Constitution, which was the act of the people, and disregard the statute, which is merely the act of the legislature." Close quote. John Marshall himself, as a delegate to the Virginia Ratifying Convention, said on June 20th, 1788, quote, "Can the Congress go beyond its delegated powers if it were to make a law not warranted by any of the powers enumerated? It would be considered by the judges as an infringement of the Constitution, which are they to guard. They would declare it void. To what quarter will you look for protection of an infringement on the Constitution if you will not give the power to the judiciary?" Close quote. The delegates that crafted the Constitution seem generally to have just assumed that the judiciary would exercise the power of review. And there were textual bases for judicial review in the Constitution itself. The words judicial review does not appear in the Constitution, but the delegates at the Constitutional Convention agreed to the establishment of Supreme Court only after they rejected a council of revision to scrutinize congressional legislation to ensure it comported with the Constitution, and rejected a second review council, which was to act as a negative on all state laws. Article 6 made the Constitution the supreme law of the land, and Article 3 said the federal courts were named as interpreters of the law. The same conclusion can be reached by combining Article 1, Section 10, which placed certain direct limitations on state legislatures, with the Supremacy Clause, and Article 3. Even Hamilton and Federalist 78 accepted the anti-federalist view that the Constitution would permit judicial review, but denied this meant judicial supremacy. Judges, after all, had neither the power of the purse or sword, so even with judicial review, the judiciary represented, in his famous quote, "the least dangerous branch of the federal government." Even before Marbury, there was no small number of cases asserting judicial review. In a Stanford Law Review article, William Michael Traynor cites 31 cases that invalidated statutes on constitutional grounds between the adoption of the Constitution and Marbury. So just as state courts began to exercise judicial review before 1789, review powers were generally assumed in the new federal courts after ratification. Marbury might have been the first time the Supreme Court invalidated a federal law. However, in 1792, a federal court in Champion versus Casey invalidated a Rhode Island state law under the Contracts Clause. In Van Horn's Lessee versus Dorrance, 1795, Justice Patterson, writing on circuit, invalidated a Pennsylvania statute as inconsistent with that state's constitution. In Ware versus Hoylton, 1796, the Supreme Court itself invalidated a North Carolina statute under the Supremacy Clause because it conflicted with the Treaty of Paris. And lastly, according to Chief Justice John Roberts, The true importance of Marbury versus Madison is it established definitively that the Constitution is law, and not simply, as was the common belief of the time, a political document. In the Supreme Court today, a bronze statue of Marshall sits in the center of the ground floor, sculpted by William Westmore Story in 1883. The inscription on its base reads, quote, "It is emphatically the province and duty of the Judicial Department to say what the law is." Marbury versus Madison, 1803. Soon after his inauguration, Jefferson began to plot the repeal of the Judiciary Act of 1801. The Federalist has, and Jefferson wrote a friend, quote, "retired into the judiciary as a stronghold. There the remains of federalism are preserved and fed from the treasury. And from that battery all the works of republicanism are to be beaten down and erased. By fraudulent use of the Constitution, which has made judges irremovable, they have multiplied useless judges merely to strengthen their phalanx." The military metaphors are telling, reflect the growing and bitter hyperpartisanship of the emerging first-party system. More broadly, Jefferson argued that the new configuration was much too large for the expected amount of litigation and was, in fact, wasteful. In the end, his efforts paid off, and the act was repealed with a terse single page of legislation. Jefferson applauded the Congress for having, quote, "lopped off a parasite limb." The newly emboldened Democratic Republicans, after taking control of both houses and the presidency, took this one step further and began a campaign to impeach as many federal judges as possible. They were successful and probably justified when John Pickering was impeached and removed from office. By all accounts, Pickering was a deranged alcoholic. But when they went after Judge Samuel Chase, not to be confused with the future Chief Justice of the Supreme Court, it caused a serious rift between the more radical wing of the party and those that felt impeachment should not be used as a political tool. And although Chase kept his job, the impeachment, as well as the rumored impeachment of Marshall himself, served to damp down Federalist activism in the federal judiciary and establish that judiciary could only be defended if its actions were seen to be truly legal and not political. Under what they thought of as a constant threat after 1802, the federal judiciary, and especially the Supreme Court, kept a fairly low profile. Just as a telling aside, it was at this point that the Supreme Court decided to ditch their beautiful scarlet and black robes for the more sedate black robes that they still wear today. All right, I'd like to end this particular episode with some reflections on the so-called Revolution of 1800 and the very profound philosophical differences between the Jeffersonian Democratic Republicans and the Federalists. The Jeffersonian pyramid represented the idea that the bulk of the power in society should rest solely on the foundation of the free citizens. And each stage of authority above that should be of diminished importance and appearance in everyday life of the people, culminating with the top of the pyramid with the federal government whose presence would be nearly invisible. Let me offer an extended quotation from Gordon S. Wood's Empire of Liberty. The first part concerns the Revolution of 1800, and the last, the demise of the Federalist Party. Quoting, "The Revolution of 1800, as the Republican leader and third president of the United States, Thomas Jefferson, later called it, was as real a revolution in the principles of our government as that of 1776 was in its form. He and his Republican Party took over the presidency and both houses of Congress in 1801 with a worldview that was fundamentally different from that of the Federalists. Not only were the Republicans opposed to traditional monarchies with their bloated executives, high taxes, oppressive debts, and standing armies, and in favor of republics with the least government possible, but they also dreamed of a world different from any that had ever existed, a world of democratic republics in which the scourge of war would at last be eliminated and peace would reign among all nations. The Jeffersonian Revolution was an extraordinary and unprecedented experiment in governing without the traditional instruments of power. Governments in the early 19th century were not supposed to cut taxes, shrink their bureaucracies, pay off their debts, reduce their armed forces, and diminish their coercive power. No government in history had ever voluntarily cut back on its authority. With such a diminished and weakened government, how would the society hold together? Jefferson and their other Republican leaders had an answer, an enlightened answer that makes their political experiment one of the most idealistic in American, if not world history. They imagined that people's natural sociability and willingness to sacrifice their selfish interests for the sake of the whole would be sufficient social adhesives. And if these Republican ideas could spread, perhaps the world itself would become a different place. Born in reaction to the popular excesses of the Revolution, the Federalist world could not endure. The Federalists of the 1790s stood in the way of popular democracy as it was emerging in the United States, and thus they became heretics opposed to the developing democratic faith. To be sure, they believed in popular sovereignty and Republican government, but they did not believe that ordinary people had a direct role to play in ruling the society. They were so confident that the future belonged to them, that the society would become less egalitarian and more hierarchical, that they treated the people with condescension and lost touch with them. That's all we have time for today. The next time we'll be exploring some of the most important cases that were ever delivered in Supreme Court history.